Good afternoon. Welcome to the Analyst. Today we'll be taking up 9 newspaper articles from the Hindu and the Indian Express and discussing them. The handout for the same will be available in the description of this video for your kind perusal. Please have a look at that. The first article that we'll be taking up is related to Citizenship Amendment Act. As the government has expanded the ambit of the rules notified under the Citizenship Amendment Act, which grants Indian citizenship to the illegal immigrants coming from Bangladesh, Afghanistan and Pakistan. The second article is related to the relations between India and Maldives, as the External Affairs Minister Shri Jaishankar is on a visit to Maldives. This is the first high-profile visit from India to Maldives after the new president-elect Mohammad Muizzu came to power. The third article is related to the verdict of the Supreme Court regarding the reservation benefits to the creamy layer belonging to SCs and STs. The cabinet has said that there is no such provision of excluding the reservation benefits to the creamy layer among the SCs and STs. The fourth article is related to the Waqf Amendment Bill, as the bill has been sent to the Joint Parliamentary Committee for consideration. The fifth article is related to bail, as the former Deputy Chief Minister of Delhi, Manish Sisodia, has been granted bail. Additionally, we'll be taking up 4 Prelims Snippets as well. Now, the first article is related to Citizenship Amendment Act. The context behind it is that the centre has expanded the ambit of the rules which are notified under the Citizenship Amendment Act. The Citizenship Amendment Act grants Indian citizenship to the illegal immigrants coming from Bangladesh, Afghanistan and Pakistan. So we will be discussing the provisions of the Citizenship Amendment Act, the concerns related to it, as well as the new rules which are notified under it. This is important in GS2 under the topic governance. Now, Citizenship Amendment Act 2019 amended the Act of 1955. It provides Indian citizenship to the illegal immigrants who are coming to India from 3 countries, Bangladesh, Afghanistan and Pakistan. It gives citizenship to particular religious communities, that is Hindus, Sikhs, Buddhists, Parsis, Jains and Christians. And they have to be in India before 2014, that is, they must have entered India before December 2014 to claim citizenship under this act, and they must have fled their home country due to the grounds, that is religious persecution, or they might have been afraid that they might be persecuted due to their belonging to a particular religion. Now, the act provides that they will be accorded fast-track citizenship. Usually, citizenship can be sought in India by naturalization or through registration. The process of naturalization usually takes 11 years in India for a foreigner to get Indian citizenship, whereas the Act provides that an illegal immigrant coming to India and seeking citizenship under the Citizenship Amendment Act can get citizenship within 5 years also. It also defines the illegal migrant. The Act says that illegal immigrant will be any person who is a foreigner who has either entered India without valid travel documents, that is visa, passport, etc., or who has entered India with valid travel documents, with a valid visa, but has extended his period of stay beyond what was allowed, and hence he is an illegal immigrant now. But the Act says that there are certain exceptions. That is, the persons who will be granted citizenship under the Citizenship Amendment Act, they will not be allowed to settle down in certain areas, that is 6 scheduled areas, which include Assam, Meghalaya, Mizoram as well as Tripura. Plus, the persons getting citizenship under this act can also not stay in the inner line permit areas which are there in the states of Arunachal Pradesh, Mizoram, Nagaland, etc. So they can get citizenship under this act, but they will be allowed to stay in other parts of India but not in these parts. Now, what are the concerns regarding this act? Why it was criticized a lot? One, the act takes up a religion-centric approach. That is, it lists down the people who belong to certain religious communities, that only these people can get citizenship under this act. Whereas India is a secular country, plus there are minorities within certain religions, certain minority sects which face persecution abroad. For example, within Pakistan, which itself is a Muslim majority country, but Shias themselves face persecution in Pakistan also, because Pakistan is a Sunni majority country. Plus, there are concerns regarding the constitutionality. Under Article 14, there is the right to equality, that no person should be deprived of the right to equality, and there can't be any discrimination on the basis of religion under Article 15. Plus, under the preamble also, it states that India is a secular country. Therefore, to get citizenship under the Citizenship Amendment Act, some people might actually be forced to convert from Islam maybe to other religions which are allowed, for example, Hindu, Buddhist, Jain, etc., so that they become eligible under the Citizenship Amendment Act to get citizenship, and that will be against the right to freedom of religion, which is also contained within the Indian Constitution under Article 25 again. Plus, there are some technical shortcomings also within the provisions of the Act, that is, it lists down the names of the religions. That is, the people belonging to these religions only can get citizenship, whereas the Joint Parliamentary Committee had recommended that rather than naming the religions, why don't you use the word persecuted minorities? That will be overarching. And there can be clashes with respect to the Assam Discord also. Because as per the Assam Accord, the people who entered into Assam from Bangladesh after 1971 are all illegal migrants and they cannot be awarded citizenship. Whereas as per the Citizenship Amendment Act, the persons who have entered illegally into India before December 2014 can be allowed Indian citizenship under this act. So there might be a clash between the two. Plus, there are other issues also. For example, the act does not take into account the atheists and Jews. They also might be facing persecution in other countries and they could have also been given citizenship under the act. Likewise, certain countries have also been excluded, for example, Nepal, Bhutan, Myanmar. The people who are facing persecution in these countries, they cannot be given citizenship under this act because the three countries have also been named under the act. Then the Tibetan Buddhists, Sri Lankan Tamils, or the Myanmarese Rohingyas, they are also not eligible, although they are also facing persecution in other countries, but they cannot get Indian citizenship under the Citizenship Amendment Act. Now, what do the new rules state? The new rules were notified earlier this year around March 11th. They say that the people who are applying for the citizenship under the Act, they have to submit affidavits. That they have to submit an application form. Along with it, they will be submitting an affidavit which will be verifying the statements they made and also the character of the applicant. Plus, they should have adequate knowledge of a language which is specified in the 8th schedule of the Constitution of India. They have to submit the supporting papers also, like a passport or identity document, to show that someone in their lineage, their parent, grandparent, etc., was a citizen of the three countries which are mentioned under the Act. Now, what do the new rules say specifically? One, it is talking about the process that the applicant has to apply for Indian citizenship digitally. He has to submit an application plus a supporting affidavit, and also there has to be an Indian citizen vouching for that person's character, that person who is applying for Indian citizenship has been a person of good character and staying nearby. The application has to be submitted online to the district level committee. Earlier it used to be submitted to the collector. Now the district level committee will be empowered to scrutinize the application, to verify the supporting documents. It can administer the oath of allegiance to the person who is seeking Indian citizenship, and it can even forward the application to the empowered committee to consider rejecting it in case the applicant does not appear before the district level committee for the verification. Now, what is the empowered committee? The empowered committee consists of the head director census operations. Its members include the Deputy Secretary, Foreigners Regional Registration Office, Subsidiary Intelligence Bureau, State Informatics Officer of the National Information Commission, and the Postmaster General of the state. Additionally, it has two invitees also. One is a representative of the Principal Secretary Home of the state, and one is a representative of the Divisional Railway Manager. Now, what are the supporting documents which need to be provided by the applicant who is seeking Indian citizenship? They can include the passport, visa documents, or the birth certificate or even the land tenancy records etc. of the other countries from where they belong, that is from Pakistan, Afghanistan or Bangladesh. And they have to provide a document to verify their entry date also. Entry date into India, it can be a visa stamp or a document issued by the Foreigners Regional Registration Office, that is to prove that they entered India before December 2014. And once this process is complete and the person is granted Indian citizenship, a digital certificate will be issued to him. Now let's take up a sample mains question also. The Citizenship Amendment Act 2019 has been a significant legislative measure in recent years. Analyze the key provisions of the Citizenship Amendment Act 2019, highlighting how it amends the earlier Citizenship Act of 1955. Please try to write it. Now, the next article is related to the relationship between India and Maldives. The context behind it is that the External Affairs Minister Shri Jaishankar is on a visit to Maldives. This is the first high-profile visit from India to Maldives after the election of the new president-elect Mohammad Moisu. This is important in GS2 under the topic India and its neighborhood relations. Now, Maldives is a strategically located country near the equator and its capital is Male. It is located in the Arabian Sea. First, let's look at the evolution of the relationship between India and Maldives. Maldives got independence in 1965. After that, the Gayoom regime came into power in 1978, and a decade after that, in 1988, there was a coup attempt against the regime of President Gayoom. India helped Gayoom in that time, and with the help of India, the coup attempt was thwarted and the operation was Operation Cactus, in which India helped. In 2008, the President Nasheed came into power, and during his regime, there was security cooperation between India and Maldives. India gave 2 helicopters, Dornier aircraft and patrol boats. India loaned these to Maldives for maritime surveillance, reconnaissance and Coast Guard operations, etc. But in 2013, President Yamin came into power. President Yamin had a pro-China stance, and therefore he signed a free trade agreement also with China, and he allowed China to invest in Maldives. Various investments included investments in Hulumale, island housing projects, the building of a friendship bridge between the Maldives and China. Then in 2018, President Ibrahim Mohamed Solih came to power. Now, the President Ibrahim Mohamed Solih had an India first policy. Therefore, he encouraged India to invest in Maldives, and the relations between India and Maldives improved. And therefore, India started investing in the Greater Malay Connectivity Project. It also signed in 2021 the Uthuru Thilafalu project to maintain a Coast Guard base in Maldives. This was an agreement. This agreement in 2021 led to an outrage in Maldives and calls for India Out policy. This India Out campaign was actually supported by the current president-elect, President Mohammad Moisu, as well as the earlier President Yamin as well. The India Out campaign is essentially to call India to remove its military presence from Maldives. Now, what is the significance of Maldives for India? Both the countries need each other. Looking at it from a geo-economic perspective, Maldives is a strategically located country. It is located in the Arabian Sea and nearby the sea lanes of communication pass. And 80% of India's energy imports are through the sea lanes of communication which pass in the vicinity of Maldives. Maldives also needs India, as India is the second largest trade partner of Maldives, and India invests in various infrastructure projects in Maldives, for example, the Greater Malay Connectivity Project. From a geopolitical perspective also, the Maldives is a member of various regional organizations in which India has a significant say. For example, Maldives is a member of the Colombo Security Conclave. It is also a member of the Indian Ocean Rim Association. It is a member of the SAARC as well as SAGAR, that is Security and Growth for All in the Region, which is an initiative of India. And it supports the permanent membership of India in the United Nations Security Council also. From a security angle, India needs Maldives, as Maldives acts like the first line of defense against terrorism emanating from sea, against various threats from the sea, for example piracy. If India maintains a coast guard base in Maldives, India can tackle piracy easily and the navy will be able to operate easily in the region. And for drug trafficking and narcotics etc. also, these are the areas of cooperation in which India needs Maldives. Plus, Maldives acts like a toll gate between the choke points of the Indian Ocean region. That is the choke points in the Western Indian Ocean, the Strait of Hormuz and the Gulf of Aden, and in the Eastern Indian Ocean, that is the Straits of Malacca. There are various exercises which are conducted between India and Maldives, including Dosti, Ecuvarine and Operation Sealed, etc. Looking at it from the perspective of diaspora, India has been sending humanitarian assistance to Maldives. India has been investing in the high impact community development projects, as well as through the Operation Sanjeevani, it gave medicines and Covishield vaccine etc. to Maldives during the time of COVID. Now, what are the challenges in the relations between India and Maldives? When we look at it politically, the challenges include the calls of India out campaign in Maldives, the calls of military presence should not be there from India in Maldives, and also the present regime has not renewed the hydrography agreement with India. Plus, there is the threat of radicalization. In the past decade, there has been a steady increase of people from Maldives joining violent extremist organizations like the Islamic State and joining terrorist groups even in Pakistan also. Therefore, it gives an opportunity to Pakistan to make the Maldives as a staging ground for launching attacks, terrorist attacks, extremist violent attacks on India. Likewise, there is a growing Chinese influence also, because the current president also has been a vocal supporter of the India Out campaign and has been having a policy which is tilting towards China. Plus, there is the challenge of climate change. Both India and Maldives are significant victims of climate change. As Maldives is a low-lying island, there is a risk of submergence also due to the rising sea levels, and there is a risk due to the marine heat waves. Now, what are the suggestions how India can overcome the challenges with Maldives? One, we have to engage with the new government which has come in power. We have to convince them that the community development projects, the investment projects which India is taking up in Maldives, they are for the welfare of the general population of Maldives. They will be having positive impacts, plus it will generate goodwill for India also. We can give more developmental assistance, and it should be in the areas which have larger impact on the larger populace. We should ensure that the infrastructure projects that we take up, they should not be delayed. That enhances India's credibility that India is a good alternative to China. Rather than seeking investments from China in infrastructure projects, why not invite India to invest in infrastructure projects in Maldives? Plus, we can upgrade our own infrastructure also. To build our own capabilities, we have commissioned the INS Jatayu naval base in Lakshadweep, and we have upgraded the facility in the Agaliga Islands where we have a base in Mauritius. Plus, we can give more financial assistance to Sri Lanka so that we have a hedge also in the southern region. There is a sample mains question. Discuss the significance and key challenges of India-Maldives relations. Additionally, suggest measures to strengthen this bilateral relationship and for addressing the existing issues. Please try to write this. Now, the next article is related to the Supreme Court verdict regarding the exclusion of the creamy layer among the scheduled castes and scheduled tribes from the benefit of reservation. The context behind it is that the cabinet has said that there is no provision for the exclusion of creamy layer in the SC/ST reservation. This is important in GS2 under the topic governance. Now, what is the Supreme Court verdict regarding the creamy layer reservation among the SC/STs? First, let's understand that. The Supreme Court has said that the states have the power to subclassify. That is, they can categorize the scheduled castes and scheduled tribes in the states into subcategories. They can further classify them. This will lead to better targeting because usually it is observed that the same strata among the SCs and STs keep on getting benefit of reservation. That is, the same families keep on getting the reservation over generations, or the same strata which belongs to the upper class among the SCs and STs gets the reservation benefit. And if they are subcategorized, then the creamy layer can be excluded and it will lead to better targeting of the reservation benefits. The court has said that this classification has to be done on an empirical basis. That is, the states have to collect quantifiable data. The categorization can be done on the basis of empirical data, which can be on the basis of education, income levels, assets, etc. But it has to be justifiable. And the same principle of subcategorization which is done for the OBCs can be applied. That is, the people who belong to OBCs but are among the creamy layer cannot get the benefit of reservation after the Indira Sahni judgment. Now, the same principle can be applied as per the court for the reservation benefits among the SC/STs also. The court said that there have to be certain safeguards. That is, it will be subject to judicial review so that the state governments, they are not using it for political gains. It is not misused to include or exclude certain communities within the SCs and STs, and therefore it will be subject to judicial review. And the court has said that there should be a generational limit to avail reservation. That is, if any member of a family has availed the benefit of reservation to increase the social status, social standing, or the economic class, then the further generation in the family should not be able to avail the reservation benefit. This has to be ensured by the state. Now, there are arguments both against this and in favor of this. First, let's look at the arguments in favor of the Supreme Court judgment. One argument is that it will ensure social justice. It will further increase the equity, the social equity among the society, because the benefits will be percolating to those stratas which are belonging to the lower class in terms of economic class or social standing within the SCs and STs also. And it is constitutional also, that the Supreme Court judgment is constitutionally valid. It is not violating Article 14, that is ensuring the right to equality, as the court has observed in its earlier judgments also, that the right to equality should not be seen from a myopic point of view. Rather, the broad view is that the right to equality ensures not only procedural equality but also substantive equality in the case of India. And it is also not violating Article 341, which is giving the definition of the SCs. And the court has said that the states, they have the constitutional authority. The states have the constitutional authority to further categorize the SCs and STs, to subclassify them. And another argument is that the social reality also paints the same picture. That is, there is inequality within the SC/ST communities, which has been observed through various caste surveys also. For example, the recent caste survey done in Bihar has revealed that within SCs and STs also there is significant discrimination as well as inequality. For example, when we look at the education levels, just one person out of 10,000 in the Musahar community has attained a higher education professional degree. Whereas when we look at the Dhobis, then it is more than 100 out of 10,000 people in Bihar. So there is significant difference both in terms of education as well as income levels within the SCs and STs. Plus, this verdict will ensure that the policy making which will be done by the state governments, which will be driven by data. and hence it will be based on the empirical justification, and it will be setting the right precedent going forward. But there are certain arguments against this judgment also. For example, one, the judgment says that empirical data has to be collected, quantifiable data has to be collected by the state governments before they categorize the SCs and STs further. Now this data collection will be resource intensive and a time consuming process. Plus the criteria for sub-classification, it will need devising of specific parameters, specific thresholds above which the certain parameters have to be satisfied for them to be included in the creamy layer, for example, the education levels, income levels, asset holding levels, etc. Plus there will be political risk. That is, the political parties may start giving reservation to certain communities within SCs and STs for making political gains. It might even lead to more social tensions. It might lead to the exacerbation of the existing social tensions within the SCs and ST communities. Plus it will increase the administrative burden. So going forward, we have to ensure that we have to build a consensus before taking such a step. There is a sample means question also. In light of the recent Supreme Court verdict, analyze the implications of excluding the creamy layer of SC/STs from the benefit of reservation. Please try to write this. The next article is related to the Waqf Amendment Bill. The context behind it is that the bill has been referred to a joint parliamentary committee to examine its provisions as it is contentious. This is important in GS2 under governance. Now, the Waqf Act regulates the Waqf properties, the Waqf Act of 1995. What are Waqf properties? The Waqf properties are movable or immovable properties which are for the purposes which are considered pious, religious or charitable under the Muslim law. And once a property is declared as Waqf by a Muslim, then that property is regulated by the Waqf board, which uses it for the pious, charitable or religious purposes. And for this, in every state, the Waqf board has to be constituted under the Waqf Act 1995. Now this Waqf Amendment Bill seeks to amend the Act of 1995. What does this bill say? One, it is making changes with respect to the formation of Waqf. That is, for declaring any property as Waqf property, that is, it can be used only for charitable, religious, pious purposes, etc. Now it can be declared only by a Muslim who has been practicing Islam for at least 5 years. Earlier there was no such limitation. That is, the Muslim has to be practicing Islam for at least 5 years. Earlier there was the recognition of Waqf which could be done based on the long-term use or Waqf by user. But now any property can be declared as Waqf property only if the person who is declaring is the owner. That is, the ownership is a must for declaring the property as Waqf. The Waqf by user has been eliminated now. The endowment, earlier it could be done as per the Waqf alal olad, that is when the line of succession ends. Now there is an additional limitation, that is the Waqf alal olad can be done only if the rights, the inheritance rights of the heirs of the person whose line of succession has ended are not violated. That is, the inheritance rights of the heirs, including women heirs, must not be violated due to the declaration of the property as Waqf. Now, earlier the government properties could also be Waqf, but now the bill provides that if there is any government property which is a Waqf property, it now ceases to be so. In case there is a dispute, then the collector will determine the ownership and accordingly notify the Waqf board. The power to determine whether a property is Waqf or not, earlier it used to be vested with the Waqf board. Now this provision has been eliminated. The survey of the Waqf properties, earlier it used to be done by the commissioners. There was an appointment of the survey commissioners for the survey of Waqf, but now it will be done by the collector. Now there is a central Waqf council also. This Waqf council is constituted to advise the central and state governments and the Waqf boards, and the union minister in charge of Waqf is the ex officio chairperson. Earlier, the provision was that all the members of the Central Waqf Council must be Muslims. Now it has been changed to that 2 members must be non-Muslims, 2 members of the Central Waqf Council. Earlier, the provision was that at least 2 members of the Central Waqf Council must be women. Now the provision has been changed that at least 2 Muslim members must be women. Now the MPs, former judges and eminent persons who are nominated to the Central Waqf Council, they need not be Muslims, and of the Muslim members, 2 must be women. Earlier, any 2 members could be women among the members of Central Waqf Council. There are the constitution of Waqf boards also. Among the Waqf boards, earlier there used to be the provision of election of the Muslim members from the MLAs, MPs and bar councils. Now there is a provision of nomination, that is the state government can nominate 1 member each from the MLAs, MPs and the bar councils, and such members need not be Muslims. Now again there is a criteria that 2 members of the Waqf boards must be non-Muslims. At least 1 member each should be from the Shias, Sunnis and the backward classes among Muslims. Additionally, if there is a Waqf board of the Bohra and Aga Khani community among the Muslims in the state, then 1 member each at least should also be there as a member of the Waqf board of the state from these communities. Regarding the composition of tribunals, the tribunals are established to address the disputes over the Waqf. The tribunal members can comprise of a current or former district court judge as its chairperson, and earlier there was a provision that a member could also be a person who is having eminent knowledge in the Muslim law and jurisprudence. Now that has been eliminated and replaced with this criteria, that is a member can be a current or former officer of the rank of joint secretary to the state government. Earlier it was an eminent person of the Muslim community having knowledge in Muslim law and jurisprudence. The appeals against the orders of tribunal were earlier prohibited. Although writ petitions could be filed in the High Court, but now the Act itself, the bill itself provides that the appeal against the order of tribunal can be filed in the High Court within 90 days. The powers of the central government have been increased. The central government can make rules regarding the registration, publication of accounts of Waqf and the publication of proceedings of the Waqf boards. Earlier, the state government could get the accounts audited, the accounts of the state Waqf boards audited. Now the central government also has the power to get them audited by a CAG or a designated officer. The Waqf boards for Bohra and Aga Khani can also be constituted now. The earlier act provided that one separate board for the Shias can also be constituted if at least 15% of the Waqf properties in the state are from the Shia community. Now the next article is related to bail. The context behind it is that the former Deputy Chief Minister of Delhi has been granted bail. So we'll be discussing the fundamental principles of granting bail in India and a few case laws. This is important in GS2 under the topic governance. Now what are the fundamental principles of granting bail in India? The philosophy of Indian criminal jurisprudence is not based upon retribution. It is rather based upon giving chances for reform. Therefore, punishment usually should begin only after conviction. We usually have the presumption of innocence. We usually say that innocent until proven guilty in the context of Indian criminal jurisprudence. Likewise, in the Menka Gandhi case also, the Supreme Court had observed that the personal liberty can only be deprived only after the due process of law has been followed. That is, the criminal trial has taken place. Therefore, there should be the presumption of innocence, plus jail should be the exception. Bail should be the rule, and it is contained in the provisions of the Criminal Procedure Code also. For example, under Article 436, it is provided that bail should be the rule in case the offense committed is a bailable offense. Although if the offense is a non-bailable offense, in that case under section 437 of CRPC, it becomes a judicial discretion in case of non-bailable offenses. Also, there is the right to speedy trial also. It is attributed as a part of the right to life and personal liberty under Article 21. It has been observed by the court also in various cases. For example, in Husainara Khatun versus State of Bihar case, it was observed that delays in trials will lead to the violation of the right to life and personal liberty, and therefore right to speedy trial should be an intrinsic part of Article 21, life and personal liberty. Now, what has the court observed regarding bail specifically in a few case laws? In Satyendra Kumar Antil versus CBI, the court has said that arrest is a draconian measure, that arrest should be used sparingly, because under section 436 of CRPC also, it says that bail is a matter of right immediately after arrest also, and bail can be given at the police station itself, and it is a matter of right whether it is in the police station or the person is produced in front of a magistrate. And the court suggested that we can consider framing a separate law also, a separate law dealing with the provisions, the principles which need to be followed regarding giving of bail. Plus, the court said that the bail application must be disposed of by the courts within 2 weeks of making of the application by the person. In Gurbakh Singh Sibia versus State of Punjab, the court had also discussed regarding anticipatory bail, the principles which should be followed. The court said that anticipatory bail should be given objectively. Section 438 in CRPC provided for the anticipatory bail. It says that a person can seek anticipatory bail if he is having that fear, that he is having that anticipation that he might get arrested for an offense that he did not commit. In that case, he can apply for anticipatory bail in the Sessions Court or in the High Court under section 438, and he can be granted bail under this. But in Gurbakh Singh Sibia case, the court said that there should be a reasonable apprehension. Rather than mere fear that he can be arrested, there have to be some reasons behind seeking anticipatory bail for it to be allowed. Now, what are the issues regarding bail in India? One, the prisons in India are overcrowded. The prisons are running at about 118% of the capacity as per the NCRB data. And 75% of the prisoners are actually under trials, that is, whose trial has not even been completed. Plus, there is no socio-economic profiling of the under trials or the persons undergoing prison sentence. Hence, we do not have data regarding the percentage of people who were denied bail because they could not give the bail amount, and the corresponding bail data is also not available. Therefore, it leads to a disproportionate impact on the marginalized. As per some studies, it has been observed that 90% of under trials have no assets. Because they do not have any assets, they are not able to post the bail amount in case they have committed a bailable offense also, and hence they are still rotting in the prison. Plus, there are insufficient arrest safeguards also. Because usually the people who are arrested, for example, migrants, or people belonging to poor economic background, they are not able to post the bail amount, and hence they are rotting in the prison. Now we'll be taking up 4 prelim snippets also related to the topics Clean Plant Program, Regional Air Connectivity Scheme, Antitrust Laws, and OPEC+. The Clean Plant Program is a program of the government to boost availability of disease-free quality planting material for high value horticulture crops. It will enhance the yield of the horticulture crops, and it will disseminate and adopt the climate resilient varieties. That is, through this program, the clean plant centers will be set up from where the varieties can be distributed which will be climate resilient and the yield will be better. It actually protects the ecosystem through a proactive virus and disease control measures. And this program is anchored by the National Horticulture Board, and this board itself will be setting up these clean plant centers. The next article is related to the Regional Air Connectivity Scheme. The Regional Air Connectivity Scheme UDAN, that is Ude Desh Ka Aam Nagarik, is a component of the National Civil Aviation Policy. What does this scheme provide for? It seeks to ensure connectivity to the unserved or the underserved areas. It provides for the airport development through the revival of existing airstrips and airports, and also the construction of new airports. Plus, it is ensuring that the flights, they are financially viable, at the same time they are cheap. That is, they are financially viable because they are getting funds through the viability gap funding, so that airlines do not go into losses. Plus, at the same time, the airfares have been capped to make sure that there are new regional flight routes also which become operational, where there are enough flights and the common citizen able to fly. This is run by the Ministry of Civil Aviation, and this is jointly funded by both the state governments as well as the central government. This is the recent data from December 2023, that 4,500 crore has been allocated for airport development under this scheme, and there are more than 500 regional connectivity scheme routes under this, and more than 1.3 crore people have availed of the benefits under the scheme. The next topic is related to the antitrust laws. The antitrust laws are to promote fair competition among the market. It is to regulate the giants, the tech giants, to engage in anti-competitive practices. Because otherwise they go for mergers and acquisitions, they acquire the small players, the budding players in the market, and it leads to the creation of either a monopoly or an oligopoly in the market. That is, the consumer choices, they are limited because they have to avail of the services of just one or two giants who have created either monopolies or dominant market positions. The dominant market position means that they are having so much of the market share that they are able to abuse their current position and charge the rates for the services as per their whims. Likewise, Google has also entered into arrangements. These arrangements can be, for example, in terms of ensuring that it has the monopoly in the search market, online search engine. That is, it has arrangements with Apple also to make sure that it makes Google as the default search engine, which obviously gives advantage to Google because more people will be using its search engine, and then it will be getting more revenue through its digital advertising. Google's argument, although, is that it provides superior services, therefore it is successful. It is not because it is stifling competition. For this, there are competition laws. In India, earlier there was the MRTP Act, Monopolistic Restrictive Trade Practices Act. Now there is the Competition Act of 2002. Now, what are the key principles of the antitrust laws? Usually they are to prevent monopolies and to promote competition. They are to prohibit price fixing and bid rigging. The price fixing is usually done by cartelization, that is, two or more players enter into an agreement that both of them will be charging more from the consumers for higher profits. Bid rigging can be, for example, in terms of acquiring of tenders from the government, that all of them give similar bids. It is to regulate the mergers and acquisitions and to punish the anti-competitive behavior as well. Now the next topic is OPEC Plus. OPEC Plus is a group of oil exporting nations. They determine how much crude oil they want to sell in the international oil market. Essentially, they want to control the prices, saying that we are bringing stability to the oil market. It originated in the form of the need for institutionalizing a framework of cooperation between the OPEC and non-OPEC countries, and it started from the end of 2016 onwards. The OPEC Plus controls about 40% of the global oil supplies and 80% of the proven oil reserves. Its members include the OPEC countries plus Azerbaijan, Bahrain, Brunei, Kazakhstan, Russia, Mexico, Malaysia, South Sudan, Sudan and Oman. Earlier there was the OPEC. OPEC was formed through the Baghdad 5 countries. That is, the 5 countries included Iran, Iraq, Kuwait, Saudi Arabia and Venezuela.
Now it has 12 members, that is, it includes also Algeria, Congo, Equatorial Guinea, Gabon, Libya, Nigeria, and the UAE. It is headquartered in Vienna, Austria. Thank you.